So this once again is the walkthrough guide to guardianship and supported decision-making webinar presented by Wisconsin Facets or hosted by Facets for Wednesday, April 28th. And we thank you for joining us. We'll dive into content in just a brief moment. But before we do that, we want to know a little bit about who you are. So I'm going to launch this poll. If you could just tell us which one best describes you, and you see the choices on your screen, pick only one. Most of you are going to be parent and or professional. And we've got 69% have voted. Now we're up to 77. I'm going to give it a few more seconds. All right, nobody new is coming in, so we're at 80% parents, and I know looking at pre-webinar registrations, we're of varying ages with your children, and then 20% of you are professionals, but we're glad to have all of you. So without further ado, I am going to turn it over to Vicki, who's going to be our presenter for the evening, and she can introduce herself.
Sounds good. Thanks, Matthew. Hey, I wasn't able to see the poll just now, so I don't know when we do them later in the presentation if you maybe want to read them off. But,
I will.
Okay, great.
That's a moderator function right now, though. I know we were seeing your PowerPoint on the screen. Now I'm seeing your webcam. So there we go. It's back.
Okay. Yeah, it was paused when you did the poll.
Okay.
So.
Okay.
All right. Good evening, everybody. I am looking forward to doing this presentation with you all tonight. So we are going to cover a lot of ground. There's an entire spectrum of decision making, all the way from informal supports all through guardianship. So I'm going to try to touch on all of that. A little bit about me. I'm an attorney. I've been out of law school. It's going to be 10 years really soon. And my firm does disability law across the lifespan, from helping the youngest kiddos get services through birth to 3A or special education, county funded services for high needs kiddos, civil rights, all the way through guardianship, decision making, special needs planning. So pretty much any area of that disability touches on, which is literally every area of the law. Either myself or my partner handle most of those things. I also have a particular interest in juvenile and children's law, and advocating for the best interest of children. My connection to disability world is that I am the older sister of my younger brother. Has had an IEP, has a physical disability, has a neurological disability, and going through life with him is what made me want to go into this field of law. I have my own firm with my partner Rock Pladel. He has been doing this for 40 plus years. He's really a pioneer in this area of law, so still have a lot to learn from him. And helping families break down barriers is our passion. So a lot of people have the question, when do we start thinking about what decision-making option is going to be appropriate for my child? I don't think it's ever too early, but I think during the transition planning process in the IEP is the perfect time. So once that kiddo is 14 years old, part of the reason for that is part of the consideration with guardianship is whether there is available education, training, or support that could help avoid the need for guardianship for that person. So there's an opportunity to really work on, you know, the transition plan. If there are areas of need that could be improved upon, that discussion can start happening early. At around age 17, if you think this may be something necessary for your child, it's a good time to consult with a professional, either a doctor or psychologist, and have them weigh in on what might be appropriate. Powers of attorney and supported decision-making agreements can be done only when the person is 18 years old. Guardianship, you can actually have your hearing when they're 17 and 9 months. So you can get the process started when they're 17 and a half. So at age 18, the young adult is able to make all their decisions, including, you know, medical, deciding whether to continue school, social services, all those things. And they can also sign contracts, apply for licenses, and make lots of financial decisions, including applying for a loan or credit card. So these are things that cause parents to be concerned. So we want to make sure that anybody is making an informed decision, and there are pieces that go into that. So you not only have to be able to understand the information needed to make the decision, but you have to understand what the outcomes or consequences are, be able to express that decision in a way that other people can understand you. That doesn't mean, you know, in a traditional, that you have to do that in a traditional way, but you need to be able to express it. It does not mean a perfect decision every time or the first time. So I think often people with disabilities who are subject to guardianship or other decision making aren't given the opportunity to make mistakes that other 18-year-olds make. I think all of us, upon reflection, would certainly say that we did not make perfect decisions every time or the first time or maybe even the 5th or 10th time as teenagers. So, you know, just making sure that our young people have the latitude to do that. So like I said, we are going to go through the spectrum, which moves from supported decision making, either informal or formal, all the way to guardianship. And in the middle is powers of attorney. POAs and guardianship both cover personal or health decisions and financial decisions as well. So we'll cover both of those things. So supported decision making, there's a quote on the screen that you can read here. So let me just say there's a big, you know, there's a spectrum of beliefs about guardianship. Some people feel that it should be done away with, that it's overly restrictive and it should never be used, and supported decision making, you know, should be the way to move forward. And unfortunately, there are, you know, people who think that it's necessary and that would use it even more so than it's currently used. I'm in the middle. I think that it's overused. I think that it's also, when it is used, it's not tailored appropriately. But I do think, unfortunately, our society is set up in a way that it's necessary to protect some people. So supported decision making is one way to help people have some protection and make choices about who helps them make decisions without taking away the rights that can sometimes be removed dealing with guardianship. So there are informal ways to do supported decision making. These have been around forever. You bring somebody along with you to an appointment, or you invite your parent to the IEP. You sign release authorizations so the person can have access to your record. From a financial standpoint, maybe you have a dual signature checking, maybe you have joint checking accounts. All these things are, not related at all to disability. They're things that anybody can do. However, in Wisconsin, we also have formal supported decision-making agreements, which is not something that every state has. The law in our state took effect in 2018, and it was passed through advocacy by various disability groups. And it expands, I guess, the ability of people who are able to use this relative to guardianship to anybody with a functional impairment. So anything that limits at least one major life activity. So if you are disabled under the ADA, you are probably eligible to do a supported decision-making agreement. You do not have to have any cognitive or mental or any specific type of disability in order to use this. These agreements cover decisions that other decision-making tools don't necessarily touch on, specifically where to work and making sure your basic needs are met. And it also covers some of the big ones as well. They also specifically deal with applying for public benefits, which is a really difficult process, both on the front end and the annual recertifications. So the creator specifies what decisions they want help with. The supporter, so for example, you could name a supporter only relative to managing finances, and that person would have no authority or no business in any of the other areas listed on the screen. A person can have multiple agreements that name multiple supporters. So you could have, different people with different areas of expertise to help you in different areas of your life. The supporter can be anybody. It doesn't have to be family. It doesn't have to be a parent or a relative. It can be anyone connected to the person, but they can't have any abuse or neglect charges against them. And an important thing with this is that the person who creates the document, the creator, the person with a disability, is making their own decisions. The supporter is not doing anything on their behalf, making decisions, signing documents, binding them in any way. This isn't a transfer of authority. It's a way to assist someone in decision making. And it doesn't require that the person includes their supporter in every decision, even if they've named them as a supporter for that particular area. Another important thing about this is having a supported decision-making agreement can't be used as evidence that you're incompetent. If somebody were to bring a guardianship action against that person, they couldn't say, well, look, Vicki did a supported decision-making agreement, so that is an indication that she's not competent. So the supporter can do several things, and these have to be authorized by the creator. And we kind of talked about the pieces of making an informed decision. So gathering the information, helping the person understand it, the information that is, and then understanding the consequences or the outcome or what, responsibilities or obligations that would create in them, and then actually communicating the individual's decision to other people. I had a client who had a supported decision-making agreement who had a cancer that affected his ability to speak, and he was completely competent. He had no diagnoses other than that speech issue, but it was very difficult for people to understand his speech, and he used a supported decision-making agreement and a supporter to help him, communicate his decision and make clear that he was using this person who was a friend as a speaker, as a mouthpiece. And the supporter, as I mentioned, can only have access to the information that they need to for the information or the types of decisions that they've been nominated to support for. In addition, they still have to sign release authorizations. It doesn't take the place of signing those. So in order to do a supported decision-making agreement, it has to be created knowingly and voluntarily, needs to be signed in the presence of 2 witnesses or notarized, and or notarized, you can do both. There are provisions for terminating it. You know, it can be revoked, it can have an end date. The supporter can also resign. And there are also automatic things that would terminate one if the supporter were to be found to have neglected or abused someone, even a different person, or an individual at risk injunction was granted against the person. So this was kind of a way that was built into the legislation to protect people from someone who might be trying to take advantage of them. So before we go into that, into powers of attorney, I'll ask if there are any questions.
We have one so far. This person is wondering, are supported decision-making agreements created in Wisconsin honored in other states?
So I don't have personal experience to answer that question, but I would believe, I mean, conceptually, I would say the answer is yes, and like the full faith and credit concept, but practically speaking, if you take one to a state that doesn't have supported decision-making agreements in the law, they're not going to understand what they're looking at. So I don't know how portable it would be over state lines if that state, like practically speaking, even if they would respect it, that might pose some issues, practically speaking. So that's a good question. Sorry, my answer is not better. Any other questions?
Nope, that's all we have right now.
All right, why don't we do one of our poll questions? So I have a handout that I would do if we were all in person somewhere about kind of
do have it.
So we're gonna do some of these as poll questions. So Matthew, do you want to do the first one?
Yep. Okay. Oh, that is not. All right. There we go. Okay, so it should have launched, but I'm not seeing it either. Hold on. I'm not sure, Vicky, if this is the first one, but what I have up right now is a child in high school, is in high school and still living with parents. When he or she turns 18, the parents can still keep making decisions.
All right, so the question is that fact or fiction?
And our voting numbers are going up. So far, I would say we have a consensus. We're at 68% of you having chimed in. Okay, now climbing. A few more seconds. All right, so I'm going to close this. Vicky, do you want to disclose the answer, or are we going to play off of what the people said?
Let's hear what the people said. I can't see it, so tell me how
Okay, yep,
what the breakdown was.
that's a moderator function, so that'll continue throughout then. But the everyone said that this is fiction.
Everyone did.
Yes.
Okay, that's good. So oftentimes, I think I hear people assume that, you know, oh, my kid still lives with me, they're still in high school, you know, why would I not continue to be a decision maker, you know, educationally or otherwise, while they're still under my care. But that is not that's not the case. Once they're 18, that authority transfers to them unless something is done to change that. So good. I don't know if I've ever had 100% right on that one, so good for you guys. All right, let's get into powers of attorney. So I'm going to say that this is kind of the middle of the road, but that's not necessarily true, because everyone should have, who's an adult, should have a power of attorney in place for healthcare and finances, regardless of whether you currently have a disability or not. And the reason for that is at any time, any one of us can become incapacitated and need assistance making decisions, whether it's permanent or temporary. So everybody should have one. That being said, is it appropriate to do a power of attorney? These are some questions I like people to consider. Is the person, do they understand that they need help and they're willing to accept it? Are they willing to share some decision-making power? And does the person understand what they are giving up, or you know, what it actually means to do a power of attorney, or are they just, you know, signing something that is put in front of them?
Vicki,
So,
we have a participant chiming in with another question on supported decision making, if you don't mind.
oh, okay.
It says, can you give supported decision making a try for a year, and if it does not work, then pursue guardianship?
Sure, absolutely. There's no, in the past, gosh, I just did a guardianship a couple months ago for a gentleman who was 50. And they were giving other stuff a try for, you know, however many years that is since he was 18. So there's no limit that says if you don't do it out of the gate, your time is up. I actually think that giving it a try and having it not work is one of the strongest arguments you could have for guardianship. So long answer to short question, yes, you could do that. And you know, people often ask the opposite, like, can I do guardianship now until, for example, until they're 21 and they get out of their 18 to 21 program and then terminate it? You can, I mean, but the thing with guardianship is that it's all evidence-based. So if there was evidence to support it at 18, is there going to be evidence that it's no longer necessary at 21? And if you think that's the case, that might be a route that you take, but I think it's certainly easier, in quotes, to try the less restrictive thing first. Any other questions?
Thank you. Nope. You may continue.
Okay. So powers of attorney are financial powers of attorney can be effective immediately, or they can become effective based on some contingency, usually being incapacitated. They last either until death of the principal or the person who creates the document, till they're revoked, or some specific time provided for them to terminate. Unless it's otherwise specified, you may have heard this called a durable power of attorney. That means that it's still valid even if the person is incapacitated. So this is a substitution, well, or at least a supplementation. This is giving another person decision-making authority so they can do things on your behalf. The creator is the principal, like I mentioned. The person receiving the power is called the agent. In order to be considered competent or capable of doing this, the person has to select an agent, understand their income and assets, and understand the power that they're transferring. So, if you walk into an attorney's office and say, I want to do this, those kind of questions are what the person's going to get to make sure they really understand what they're doing. So these are disadvantages, at least in a certain light. It can be revoked at any time. So you can rip it up or burn it or revoke it in writing. If you don't like what your agent is doing, if you change your mind, you can get rid of it. There is generally no court oversight. There are provisions where you could get a court involved, but generally right out of the gate, there's no court oversight. It's not always accepted by banks. So, we're talking about, was this person competent to do this power of attorney to begin with? A bank can say, no way, this person understood what they were doing signing this document. I'm not going to accept it. Come back with a guardianship. See you later. And in that vein, the validity can be challenged. Again, mostly based on the person's understanding of what they were doing. They can challenge that someone used undue influence to get this person to do this. So those are some of the issues. Some other financial management options, not going to spend a whole lot of time here. There is a such thing as a conservatorship that allows assets to be managed, but without a finding of incompetence. And then there are special needs trusts and ABLE accounts. That's probably another whole presentation. There's also the representative payee, which I have a whole slide here for. So if somebody receives Social Security, it's managed in a separate account used for the person's support and maintenance, and Social Security has its own reporting requirements. Many people, especially 18-year-olds, don't have a large estate to manage. Social Security may be their only income, and many people are able to, manage that money through being a rep payee. So, powers of attorney, two different, areas they cover. The other area besides finances is healthcare. So, a principal must be at least 18 years old and of sound mind. It doesn't necessarily define what of sound mind means. It just means no finding of incompetence. So once you have, if you have a guardianship in place, you cannot then create a healthcare power of attorney after that. Same terms, principal is the creator, person who gets the power is the agent. It takes effect upon a finding of incapacitation by two physicians or a physician and a psychologist, and this has recently been amended to include other healthcare professionals such as a nurse practitioner who personally examine the person and sign a statement saying that they are incapacitated. Just being old or eccentric or having some physical disability does not equate to being incapacitated. An agent has various duties and responsibilities by law to follow the person's wishes and desires, to follow their living will, to the extent that they don't conflict with each other, to sign any documents or waivers or anything necessary to realize the person's wishes related to their health care. And it also touches on making anatomical gifts. It can be revoked just like the financial power of attorney at any time. Powers of attorney do not touch on educational decision making. There is a document I've linked there, a specific POA for that. It doesn't touch on Social Security. You still need a rep payee if the person needs it. Obviously, not every person who gets Social Security needs a rep payee. So before we go on to guardianship, Do we have any questions about powers of attorney?
We do not yet. Perhaps they are taking it in. We can certainly see what comes in as folks have an opportunity to type.
All
But
right.
I suspect that you want to launch poll number 2, question number 2.
You suspect correctly.
So this one says, many people under guardianship are not allowed to vote in any elections because their guardianship agreement says so. Fact or fiction? You got over half of you having voted now. A few more seconds. We keep climbing here. Let's see if we can get to 90. We're at 87% have voted. Some might not have their screen up or be away from their screen. All right, we've had no late movement, so I'm going to close this. So this was much more of a split decision. 55% of the audience said fiction, 45% said fact. I'm going to chime in real quick. I think it's a fact. So who is correct?
It is a fact that many people under guardianship have their right to vote removed at the time the guardianship is entered. When we're going to get more into detail about all the areas that guardianship touches, but this is something that disability rights Wisconsin feels strongly about. I feel strongly about. Many people do. There is some research done recently that in the elderly dementia population, about 96% of people still had the capacity to vote. And that this is something that's being overly taken away from people under guardianship. So we'll talk more about that, but that is a fact.
Before we do the deeper dive, we did have a question on healthcare POA, asking very simply, does healthcare power of attorney, do the agreements need to be notarized?
Healthcare power of attorney is done in the presence of 2 witnesses and can also be notarized. But I think if you print one, you can print one off. There's a link later in my presentation. You could do it in your living room and have your 2 neighbors come over who are not related to you, and they could be witnesses, and you could do it without a notary.
Okay, now we've got, as dialogue flows, we've got another question. Can POA's representative payee and HIPAA release form all be connected to supported decision making?
So for my clients, if somebody has is going to do a supported decision-making agreement, I also recommend that they do powers of attorney at the same time, because they are, they complement each other. They're 2 different things. HIPAA releases. So if you have a supported decision-making agreement, you would still have to sign or have the person sign HIPAA releases in order for you to have access to the records. If they had a power of attorney and it was activated, then the assumption would be that you would be able to have access to what you needed to in order to act as their healthcare decision maker. So, you know, they're definitely all interrelated and connected. And I think, like I said, if you have a supported decision-making agreement, that is great for when you can make your own decisions with or without support. But the power of attorney, like I said, everyone should have one for when you are incapacitated and can't do it. And that would be the backup in this situation.
So, okay, thank you. We've got a couple things more now on supported decision-making. Pretty specific one. Can you put a clause in a supported decision-making and agreement to get the creator out of jury duty?
Not that I know of.
All right. And then the final thing for the moment is, can you have a supported decision-making agreement? Are you still able to be the rep payee, or what makes a rep payee?
Yeah, so you can have a supported decision-making agreement that names your mom as your supporter for a whole bunch of stuff, and then also have your mom be your rep payee. And that process is done through Social Security when you're applying, or if somebody doesn't have a rep payee and receives Social Security, I think you can reach out to Social Security and say, this person needs a rep payee, here's why, I want to be it. So that is done through the Social Security Administration.
Okay, thank you. That's all for now. I think it's a good time to dive into guardianship.
All right, so guardianship, we've got the courtroom in the picture there. This is, you know, done in a court of law. It's a serious, you know, proceeding. It's permanent, you know, lasts either until death or modification by the court. So it's serious business. So as I mentioned, a person has to be at least 17 and 9 months when the guardianship is entered, which is when you have your hearing date. The person's need or the individual's need for assistance in decision making is unable to be met effectively and less restrictively through appropriate and reasonably available training, education, support services, healthcare, assistive devices, or other means. Okay. And that the individual will accept. So all of these things are part of the consideration of whether guardianship is necessary. And that's what I mentioned earlier, you know, is there training, education, and support that could obviate the need for this? Let's talk about voting. You know, no, this person can't vote. They don't understand the electoral process. They don't know how to register to vote. They don't have an ID. They don't understand how a ballot works. Quite possibly everything I just mentioned could be addressed if efforts were made to educate and support and train that person in all those areas. So that's just an example. You can imagine that could apply to any type of decision making. Oh, and then it bolded there that the individual will accept. So if things exist that would work, but the person is resistant to them or refusing them, then that gets you back into the, well, maybe we need an alternate decision maker then. So 2 types of guardianship: person and estate. Person is personal healthcare decisions, estate is financial. The guardian of the person exercises some rights, makes important decisions, does not make financial decisions for the most part. Some key terms for you to know is that the petitioner is the person who asks for the guardianship. The guardian or proposed guardian is the decision maker if the court approves, and the ward or proposed ward is the person who is under guardianship. I don't like the term ward. A lot of people don't like it. I use individual whenever I can. I always tell my clients when we're going into a guardianship hearing that you're going to hear that word. You're going to hear the word incompetent. That's the language that's in the law. Unfortunately, it's hard to hear as a parent, as a person, but unfortunately, terms we have to deal with to get through one of these hearings. I mentioned earlier that guardianship is evidence-based. So there's a state form that needs to be filled out called the examining physician's report. A doctor or a licensed clinical psychologist or both examine the ward. And there's a statement of rights that they need to read to the individual prior to the examination taking place. And this is going to provide the basis for the guardianship. Not only do they need it or not, but what are their disability-related needs? What rights are they able to exercise independently or with support, or should be transferred to the guardian? And if necessary, it addresses their placement if they need to be protectively placed, like in some type of facility. So the standard is because of an impairment, an individual is unable to receive or evaluate information or make or communicate decisions to such an extent that they cannot meet essential requirements for their health or safety. That is a legal standard that's plucked straight out of the statute. What is an impairment for purpose of guardianship? There are 4 categories: developmental disability, serious and persistent mental illness, degenerative brain disorder, and other like incapacities, which is kind of the catch-all. So I have examples of some of those on the screen. There are 3 categories of rights under guardianship. First is rights that are removed in full. The individual can't do it and nobody can do it for them. The next category can be either removed completely or exercised with consent, but the guardian can't do it on their behalf. And then finally, there are rights that can be transferred to the guardian either in full or partially. So the ones that can be removed: serving on a jury, executing a will, or voting in an election. So we talked a little bit about voting. Executing a will is, obviously control of your personal property after you're gone, a big deal. And serving on a jury, no one's favorite thing to do, but one of our important civic duties, and also important for the person, or the people in that trial, is that they have jurors sitting on there that are able to understand and make and communicate good decisions. Rights that, the next category are rights that can be exercised with guardian consent. So sterilization, marriage, organ tissue bone marrow donation, and licenses, which includes driver's license, hunting and fishing, and other, I'll call it hunting related licenses, and then professional licenses or credentials. So certain professions, you need to have a license in order to practice, barber, social worker, attorney, etc. Those type of professional licenses. So these rights can either be retained by the individual, removed in full, or that the person can exercise this right with guardian consent. The guardian can't do it for them. So the guardian can't make someone get sterilized or married or any of these things. They can allow the person to do it with their consent. Sometimes people are like, oh my God, I would never get my child sterilized. Why is this on here? It's on there because people with disabilities were sterilized without their consent up until not very long ago. So that's why it's on there. Doesn't mean that you want to, that you will. It's more about making sure that nobody is going to make that decision for your child, instead of you or instead of them. So rights transferred to the guardian are healthcare decisions, and that's, choosing providers, releasing records, choosing medication or course of treatment, all those major medical decisions. including, and here's another one, experimental treatment or research. You know, again, people are like, I would never put my kid in a research project or, you know, experimental treatment. And that's the point is, you know, do we want the person to be able to give consent to those type of things independently? And if that right is transferred, there are very specific parameters on the guardian for when that could actually be acted upon. Social services, educational decisions, vocational decisions, protective placement, etc. All these personal decisions can be transferred to the guardian of the person. Acting as an advocate for them in all proceedings that do not involve money or finances, receiving notices, dealing with divorce if they do have the right to marry, making sure they have the right to end that marriage and make decisions about that. Mobility and travel, where you go when and with who. There are a couple other things, and ultimately one of them is having custody of the individual or of the ward, same way as you have custody of your child when they're a minor. So this touches on every single area of life. There are full versus limited guardianships. So in a full guardianship, everything that can be removed is removed. Everything that can be transferred is transferred. In a limited guardianship, the person may flat out retain some rights where the guardian has no say. They may be given input into decision making, or the guardian's authority may be limited in some way. According to the law, the person is already supposed to be able to participate in decision making to the maximum extent possible. However, sometimes that's written into the guardianship order in specific ways. One example is, you know, choosing social service providers. It might say the person is able to make their own choice from options pre-approved by the guardian, for example. That's a way it could be limited. For the guardianship of the estate, the standard is similar, that the person's impairment makes them unable to receive and evaluate information or make and communicate decisions related to property management and their financial affairs to such an extent that they're either going to lose their property in whole or in part, they're going to be financially exploited, or they're not going to be able to support themselves. So again, a high bar. The guardian of the estate has to provide financial support using the individual's money, not their own. They can enter into some contracts, settle claims. They're responsible to provide an annual accounting to the courts of everything that comes in or out. So I put in here, probably not necessary for most 18-year-olds. While I think that it depending on what county you're in, there are wildly different practices about whether or not an 18-year-old who only has Social Security income needs a guardian of the estate. So for that, I'm going to say it depends where you are in terms of what your court is going to want. It also, even if you start out with no guardian of the estate, it can become necessary in the future if the person comes into some money that might put them in jeopardy of losing their public benefits, like an inheritance, or if they settle a personal injury case, any other unexpected money. Sometimes even if you get back pay for Social Security, that can cause problems. So even if you don't have one to start, you might need one in the future. There are often many people involved in a guardianship. So a guardian ad litem is an attorney appointed to represent the individual's best interest. It's their job to meet with the proposed ward and the proposed guardian or guardians, advise them of their rights, collect whatever collateral information is necessary, and then they report to the court and appear at the hearing and make a recommendation. Someone who there's a guardianship petition for has the opportunity to object and ask for an attorney to be appointed for them to represent them and their wishes. So it's different than the guardian ad litem. And that attorney is going to advocate for what that person wants. And then it's required that the county of residence or the county where the petition is filed gets notice. So the county has an attorney called the Corporation Counsel, and if the person receives benefits, the Department of Health and Human Services in that county receives notice as well. Depends on the county whether or not that attorney participates in the hearing, but they are required to get notice regardless of where you are in the state. So I've got some resources here. I'll just go through these and then we can go back to poll questions or polls and questions. So the Marquette Volunteer Legal Clinic, I believe they're still doing everything virtually. They can help people do guardianship paperwork, which is really helpful if you're doing it and don't have an attorney, but you do need to have your doctor's report already completed. There are some links here for the Guardianship Support Center, the National Center for Supported Decision Making. Here in Wisconsin, the ARC is a great resource. So is the Board for People with Developmental Disabilities. And then there's a link to advanced directives. So I mentioned earlier, you can go online and print off power of attorney for healthcare and finances off the internet, and that's what that link is right there. Here is my contact information. So I think we have a little time here. Why don't we do another poll and then we can move on to questions.
All right, now I need to, the polls disappeared from my control panel. We do have 2 questions. I'll see if I can get the polls back. Oh, I just had to show it again. So the next poll question I will launch now. This one says, I need to go to court to get guardianship over my child's SSI when he or she turns 18 because he or she can't manage money. Is that fact or fiction? So we're over 80% participation at this point. I'll give it a few more seconds. All right, we're holding at 86 for a while. In the interest of time, I'm going to close it. So, Vicki, 72% this time said that this is fiction.
Yeah, so like we talked about earlier with representative payees, there's a good chance that if that's the only income the child has, that it could be managed through being the rep payee and, you know, without going to court and getting a guardianship. And of course, there are plenty of people who receive Social Security that don't need assistance with decision making whatsoever. But in the event that you did have both, it's still not always necessary that you have guardianship in order to manage the Social Security funds.
All right, so in the interest of time, we want to be respectful of that as much as possible. We do have about 4 minutes left, 2 possible poll questions and 2 audience questions. I don't think either of those audience questions will take super long in this context. But what would you like to do, Vicki?
Let's just go to the audience, that's fine.
All right. So now I get to give you a choice. Would you like the healthcare question related to guardianship or the financial question first?
Let's do finance first.
And this person is asking, are you financially responsible for mistakes the person may make with guardianship? So I'm assuming the person means the individual and the you is the guardian. But that person may correct me if I have that inside out.
So this is a question that I get all the time. Like, am I going to be personally liable for the actions of this person? And generally, no, being the guardian doesn't create that kind of personal liability. The only thing I will say is that if you're the guardian for somebody and you're not taking the steps to protect them and act in their best interest and something happens to them, you know, there is your guardianship could be taken away, you know, potentially some exposure for that in that context. But if the person, I don't know, does something and they get sued or whatever, it doesn't make it the guardian's responsibility, you know, liability in that sense of the term. I will say again, in terms of keeping your guardianship though, if the person was able to hurt someone or whatever the case may be, your ability to continue serving as guardian may be questioned, but in terms of putting you on the hook for whatever damage they caused, that's not created by the guardianship order, if that makes sense.
Okay, thank you. So this last question, at least at this time, is from a parent who's going to be seeking guardianship of their child. It says our child is in an out-of-state residential treatment facility, and they want to know how they go about getting the doctor forms.
So if the guardianship is going to be in Wisconsin, like, so the guardian chooses residency. And so if the guardianship is going to be in the county where you reside, you would still have the, you know, use the Wisconsin form. It's available online. If you Google examining Wisconsin, examining physicians or psychologists report, you would be able to find it. And you would want the facility, most likely someone at the facility, to facilitate filling that out. If for whatever reason they weren't able to or willing to do that, I suppose now that we're in Zoom world, you might have them set up the evaluation with somebody who is willing to do it. But yeah, the forms are available online, and I would think that the facility would cooperate with getting that done, because they're gonna want your child to have a decision maker in place at the right time.
All right, so with that, I'm going to stop the recording at the moment. That's all the questions we have.